That replace the lights.
I'm usually in the other courtroom, and it's more like candlelit dinner. So this, you don't look too closely. I prefer the candlelight on my face. Haha. Anyway, welcome to the Fifth Circuit. We have an interesting docket, albeit short this morning, but we would like you to try to observe our rules, which are that when the yellow light comes on, you have 2 minutes left in your argument. When the red light comes on, we ask you to conclude as quickly as possible. We are familiar with the briefs and record excerpts. We have not necessarily read the entire record, so we do appreciate record citations when those are appropriate. We call the first case of the morning, number 23-60270, Lion Elastomers versus NLRB. We'll hear first from Mr. Cupp.
Good morning.
Good morning.
Your Honors, I'm here today to implore this court, implore this panel to establish some guardrails regarding what the NLRB did to our client, Lion Elastomers. We believe that unequivocally that the NLRB, and what we have referred to as the decision Lion Elastomers 2, violated and egregiously violated, ran roughshod over the due process rights of my client by not allowing, and in fact specifically rejecting, the company to address a sea change in the law when the board decided Lion Elastomers 2 and reverted to the Atlantic Steel standards for determining egregious conduct of an employee at work. We believe that is the first and could be the only reason why this court should reverse Lion Elastomers 2 and send this case back down to the board and or to the administrative law judge to make a different finding, and to at least give Lion Elastomers the opportunity to present its case before the tribunal.
Exactly what relief are you seeking in that regard? You want to rehear the entire case? You think the General Motors formula should be applied? Just what do you?
Absolutely, we do believe General Motors should be.
And what's your best authority for saying that?
Well, the fact that General Motors was the law at the time
when the Fifth Circuit heard it before.
Yeah, it was the law. That was the law when General Counsel petitioned for remand from the Fifth Circuit down to the board. That was the law. General Motors was the law. At no point was Lion Elastomers put on notice that the General Counsel was going to argue to completely reverse General Motors.
Do you think the General Counsel thought so at the time?
Nothing in their briefing had indicated that, and in fact, the board, just 2 weeks before we submitted, or the parties submitted joint briefs on September 3rd, 2021, affirmed General Motors, or used General Motors, to affirm a remand from the Columbia District Court of Columbia, the Constellium decision, and they cited General Motors as support for the board's, cited General Motors for support of reaching a decision in favor of the employee in that case. That was 2 weeks before the parties submitted briefs to the board. We had no notice that the General Counsel was going to argue that General Motors, which provides the right line standard for determining these cases, was going to be rejected. Of course, we believe General Motors should be reinstated, or should be the law. We think that General Motors has the rational relation to the act. I will point out that this court has not been shy in the past, both in the D.R. Horton case in 2013 and in the Tesla case, to reverse decisions by the board in which their policymaker or decision-making had no rational relationship to the act. Of course, D.R. Horton dealt with arbitration provisions under the Federal Arbitration Act. Tesla dealt with the ruling by the board that uniform policies were presumptively unlawful under the NLRA, and both those decisions were reversed. So yes, we believe that this court, this panel, should reverse Lyon and Elastomers 2, and at the very least, send that decision back to the board and to the ALJ to make a decision consistent with General Motors, which was the law of the land.
So the denial of due process would be the board's refusal to allow you to file a reply brief to the counsel's brief on remand.
Absolutely, Judge. They've refused. After we filed simultaneous briefs, let me back up for.
Well, you file a brief that says, here's how General Motors applies to our case.
That's correct.
They file a brief that says General Motors ought to be out. We need to go back to Atlantic Steel.
Okay, that's right. And then we petitioned the board to allow us to respond to that.
Right, so you file a response. If we send this back to do that, I mean, wouldn't the board still be free to do exactly what it did? I mean, I guess
Well, they could.
I'm not discounting the importance of hearing from the party before they do that.
Well, that's right.
But
Well, they could have, Judge.
I mean, there's no other guardrail, to use your word, to keep the board from changing law midstream, so to speak.
Well, other than the fact that they need to let the parties be heard on it.
But why wouldn't they do that? Once it was remanded, you'd have your notice, I'm sorry, I have allergies, so I sound funnier than usual. So why wouldn't they just go ahead and do that?
Do I, Judge? Reapply Atlantic Steel? Well, they could, but again,
No, proceed with the General Motors position, if it's remanded.
they should proceed.
You would file your brief responding that they wouldn't let you file before, right?
Yeah, that's right.
What would
Yeah,
happen then?
we would argue that the General Motors position is the position that's more rationally related to the act. At least give us an opportunity to be heard on it. They did not do that. They just wholesale determined that we're not going to hear from the party on it. We petitioned to allow them to do it. We gave them advance notice. We didn't wait for a decision to come out. We gave them advance notice that this is what we want to address based on the court's decision in line to Elastomers 2, which is the one we're dealing with here. They didn't do it. And we believe that is the guardrail that this court needs to put up, that the government agency just cannot do what they want to do and really run roughshod over the due process rights. Look, it may not have...
Articulate what that guardrail sounds like. In other words, how do we instruct the NLRB when to do it and when not to do it without dictating their day-to-day procedures or their statutory authority?
I think it's very easy. I think you say, let the parties be heard on the issue. If you're going to have a sea change in law like this, let at least the party that's being impacted be heard.
But I mean, I guess what I'm getting at is there discretion on their part as to when to allow the parties to be heard again or file a reply brief or that sort of thing, or can they deny it? I mean, what is the bandwidth there?
Well, they did deny it.
I know they denied it, but what's the bandwidth that we're to allow them to consider these kinds of requests going forward?
Well, I think the bandwidth is that the party being impacted, adversely impacted by a complete change and reversal in the law needs to be heard on the issue before
Needs to be notified, right? See, needs to be notified of the change.
Yeah, it needs to be notified and should be allowed to be heard on the change. That did not happen here. That absolutely did not happen. In our opinion, the board preordained a decision that they were going to reverse General Motors and go back to the Atlantic Steel standards. They did not provide us any notice of that. General Counsel didn't provide any notice of that. General Notice's motion to remand didn't provide any notice of that. The
That's what I was going to ask about their motion to remand. There's no telegraphing in that motion anything other than, well, the law has changed. We need to apply the changed law to this case.
That's right. The remand, the motion for remand saying that they wanted to remand to determine the effects of General Motors.
Is there any possibility of judicial estoppel?
Yes.
But
Yes. Yeah, absolutely. I think that, in this case, there could be. I mean, if the General Counsel would have said, we do not believe that on the motion for remand, we do not believe that General Motors is rightly decided, and we want to make we want to argue for a reversal of that, go back to the Atlantic Steel standards. Line Elastomers may very well have objected to that at the time. We didn't. We consented to that because we did believe that the General Motors decision, which came out during the pendency of the appeal, was the law of the land. That's what the board needed to decide this case under, which incorporates the right line standard of determining.
I assume General Motors was decided on the basis of due process, right?
Well, yeah, partly. I mean, General Motors itself, when the General Motors board came out, the three-member panel decided that the old Atlantic Steel Standard, which was a 1979 case, by the way, which was determined well before Meritor and some of the other important Title VII cases dealing with hostile work environment and other types of issues under federal and state anti-discrimination laws. The General Motors panel decided that, hey, look, this is not a sustainable way to view these cases. It's loggerheads between protected Section 7 activity and the company's obligation to deal with laws.
I mean, is it even appropriate for us to get into the merits of the General Motors versus Atlantic Steel dispute?
Well, we believe so, and we argue that in our briefs, Your Honor. We believe it is appropriate.
But we'd have to fly right by the due process violation to do that, right?
Well, I think it's an alternative. We set forth that certainly as an alternative form of relief, that reinstating Atlantic Steel was an error and not rationally consistent with the Act, given the fact of the long litany of cases decided under Title VII and other federal and state discrimination since that point.
They cite many, many cases that have applied Atlantic Steel over the years, including from this circuit. Did any of them say that Atlantic Steel was irrational or inconsistent with the law?
Not that I'm aware of, Your Honor.
Yeah.
But the General Motors decision by the three went through a bunch of cases, and they cited what they refer to as alarming decisions that have come out under the Atlantic Steel based on this concept that Title VII activity is inseparable from egregious conduct by an employee. It's excused. General Motors came out and said, no, we can separate those two, and that's not an unreasonable way to look at things, and it also balances the right of employees to engage in Section 7 activity with the rights of employers to abide by the law in other areas, such as Title VII, in other areas. And and we cite it in the brief. There's cases that say, look, the NLRB, and in fact, that's what the court held in D.R. Horton. It said the board's deference in deciding cases cannot conflict with federal statutes and policies unrelated to the NLRA. And that's what this court held, and I think, Judge Jones, I think you were a part of that panel in 2013. But that's the D.R. Horton case dealing with arbitration. And I would say that the Tesla decision is the very same. So we believe that due process requires reversal. We believe that they ignored the mandate from this court, which they should not be allowed to do, when they just wholeheartedly made the sea change in the law without giving us notice. So we have due process. They exceeded the mandate.
How do you get there, though? The opinion was only one sentence, wasn't it?
It was.
Just remanded. So how do you get to the argument that, or the position that the mandate was violated?
Well, I think you look at the petition for remand itself. I think it would have been different had the general counsel said, we would like to petition for remand because there needs to be a change in the law, and we don't agree with General Motors. They didn't do that. Their own petition for remand said, we want this case remanded, or the case should be remanded, to argue the effects of General Motors. And so what the board does, and what they argue on the other side is, they did consider that. They consider it's no effect because we're not going to keep that law anymore. We're going to revert to the Atlantic Steel standards. Okay, we get that. We weren't heard on that issue. We were not allowed to brief that.
You're back in due process now. I'm just asking about the elasticity of the court's mandate to bind or prescribe what the NLRB could or couldn't consider on remand.
I wish the mandate itself would have been a little bit clearer in that. It wasn't. It just simply said.
Was this an order granting the motion?
It was. And that's why I think you have to revert to what the motion said and what the general counsel was arguing there regarding.
Where's your law for that or your authority for that as the approach we're supposed to take?
Well, I mean, there has to be.
It's
some-
it's
within the
similar to
spirit.
judicial estoppel on their part. They sought relief from the court remand based on a certain fact, and then they get, which is the law has changed, we want to apply the right law, then they get back to the board and they say, oops, we're going to change the law.
That's exactly.
In a way.
And and what we hear is that we somehow, what you're going to hear from the other side is that we somehow waive that argument. There is no way we waive that argument. We went to the board, we asked to brief this very issue, and they refused. And in fact, they predetermined the issue in the Lyon Elastomers 2 decision.
Let me, does Lyon concede that Cologne was fired, or did he quit?
No, he was discharged after he refused to sign the last chance agreement that was presented to him.
Okay.
There was a last chance agreement
Yes.
that was presented dealing with various conduct that Mr. Cologne exhibited in the workplace. He refused to sign it. In fact, he refused to read it. And there was there was no evidence, by the way, established that there was any disparate treatment of Mr. Cologne compared to anybody else at that work site. Your Honors, I see my time is up.
Yep, you have rebuttal.
Thank you.
Thank you. Okay, Mr. FitzMauric.
Your Honors, may it please the Court, Brady Francisco-FitzMauric for the National Labor Relations Board. Very briefly, and before getting into some of the legal issues that have been discussed in this case, I'd like to take a quick moment to remind the Court of the core of the case, which is a routine application of a decades-old standard, a court-approved standard, to firmly established facts.
You know what? Your brief and your opinion, the board's opinion here, keep talking about clutching pearls. Oh dear, they overturned 4 decades of precedent. Well, it seems to me when certain administrations have been in charge of the NLRB, they turn over the contractor rule, they turn over the tip rule, they turn over uniform rules, they turn over voting rules, and then they get upset when somebody else overturns 4 decades. So don't give us that argument.
I understand, Your Honor. This is a case, dealing with a standard that's been changed. As Brother Counsel mentioned, the Atlantic Steel Standard had been in place for quite some time, and the board saw fit to overturn Atlantic Steel in General Motors.
But then you requested to remand this case to go apply General Motors, but that's not what the agency did at all. That's not what the General Counsel did at all. So basically, this is the classic surprise switcheroo that we would invalidate all the time when agencies do that without affording notice, opportunity, all those Administrative Procedure Act standards. I realize the NLRB does its thing through adjudication, right? Where's your authority to do the same thing that you couldn't do if you were making rules?
I thank you for your question, Your Honor. I'd like to
Well, you're welcome.
briefly correct the record. There was some discussion earlier about the motion for remand and the court's order granting remand. So in this case, the board filed a motion for remand, but that motion did not say it was for the board to apply General Motors. It did not say it was requesting remand to see.
Well, what else did it mean?
Well, what it said, Your Honor, was
It said remanded. I understand that, but it was based on a representation by, were you representing the board at that time?
yes, Your Honor.
So you represented one thing to the board, to this court.
Yes, what the board represented was it sought remand to determine whether General Motors affects the affects
Have you
the
ever
analysis.
done this before? I mean, he calls it surprise switcheroo, which under our governing authority is a term of art. But what about sandbagging? Have you ever sandbagged somebody on remand before like that?
No, Your Honor, and respectfully, I don't believe that the board did so in this case. The question,
That's absurd.
Where in the motion to remand did you say the board wanted to reconsider General Motors and revert to the old standard?
the board's motion did not say that.
Where did it say that the board thought General Motors was infirm and needed to reconsider what standard would apply?
The motion did not say that.
That's not what it said at all. In fact, the party opposite agreed to the motion, which basically, if it was signing its own death warrant, would probably not have done that, correct?
I respectfully disagree that it's a death warrant.
Well, call it what you want. It's a surprise switcheroo, it's sandbagging. It's nowhere in the motion to remand that the board was going to throw out the new standard that had just been implemented. It wanted to apply the new standard. That's what it represented to this court.
Respectfully, Your Honor, I don't believe that's what the motion represented.
Well, we'll read the motion and figure it
Who
out.
interprets it?
Yes, of course you do, and I'm simply asking that you look at the language in the motion.
But then we did. And then you go back to the board, and the board gives them, even if the board had authority to do that, the board gave them no opportunity to say, wait a minute, don't reverse General Motors. Now, how do you justify that?
So I would say, Your Honor, that Lion did have an opportunity. In fact, it had two opportunities to address that issue. It had the first opportunity when it filed its statement of position on remand to the
So they were negligent in not apprehending the issue and failing to raise it.
I'm not levying any allegations of
Of course you can't, because the other reading of that is the motion to remand nowhere hinted that this would be the issue until the general counsel filed its statement of position.
Again, I'll rest on the language of the motion to remand, which proposed a yes or no question to determine whether General Motors affects the analysis in this case. The board addressed that issue and answered it in the negative. No, General Motors does not affect the analysis here because it is overturned, and we're returning to the Atlantic Steel standard.
Well, how could you legitimately return to the Atlantic Steel standard on this case when the board didn't do that 2 weeks earlier?
Your Honor's referencing Constellium, which was a case on remand from the D.C. Circuit in which, Your Honor's correct, the board applied General Motors. General Motors was in effect for approximately 3 years, give or take, before it was overturned in this case. In that case, in Constellium, no party urged the board to overturn General Motors. It was
That
not.
means you.
Well, I was not a part of that case, and I was not a part of drafting the general counsel's.
Well, normally you apply the law on appeal, right? That was, in other words, if a case was pending on appeal before us and the Supreme Court made a decision that might affect it, we would remand to the district court to reconsider under the Supreme Court's new authority.
Certainly.
And nobody would argue, well, that authority doesn't really apply. Now, why should what binds the Article III courts in regard to vertical authority shouldn't also bind the agencies as a matter of due process? There's got to be some consistency, hasn't there?
I agree there must be consistency, and I think Your Honor draws a useful contrast between Constellium and the instant case. In Constellium, the D.C. Circuit analyzed the issues, analyzed the facts and the standards, and remanded with instructions for the board to address any potential conflict between its own standards and other anti-discrimination laws with those instructions. So the board did.
Oh, so it's our fault. It's our court's fault for not instructing properly and just taking the board at its word.
Absolutely not, Your Honor. It's not an issue of blame. It's an issue of Article III courts can, of course, constrain an agency's discretion on remand.
Well, we
So
can
going-
constrain it right now.
You have the authority to do so, yes, Your Honor.
Well, so what you're telling us is going forward, it is our fault. We should be writing detailed orders to the NLRB, instructing them exactly what they can and can't do?
Your Honor, I'm focusing only on this case.
Well, exactly, me too. But it was an agreed motion to remand, which we get all the time when both parties come in and request, we want to reconsider this. There's new evidence about that. Could we send it back for the other to correct some error before we can really decide the case on the merits? That's what happened here. And what the NLRB did was take it and run with it to have a sea change in the law.
I would like to point out that this idea that Lyons Counsel was surprised, or I think you said that there was an instance of surprise in this case. I would push back on that respectfully. I mean, this was a case where, following the remand, of course, the board invited statements of position. Before statements of position were filed, about a month before that.
Respectfully, you're not arguing what the board said. in footnote 69. It said, "Our dissenting colleague faults the board for not permitting the respondent to reply to the general counsel's statement of position here following remand, in addition to filing its own statement of position." The board then goes on in several paragraphs to explain, hey, Lyon loses anyway, and therefore, even if we're applying the new standard, too bad, they lose. They don't argue that Lyon forfeited its opportunity. They don't argue that Lyon was, in fact, on notice, both of which arguments you're trying to use to justify the board.
I'm only trying to...
which is post hoc justification, which you know is not allowed.
I understand that, Your Honor, but the court expressed an understanding that Lyon's counsel was surprised, and I'd like to correct that because I don't think that's supported by the record. At record, page 1022.
Well, if that were true, the board should have said they should have seen this coming and they should have put it in their statement of position. Now you're arguing their motion to reconsider or something like that was too late.
Well, the board did point out that Lyon had an opportunity to be heard first in its statement of position, and second, by filing a motion for reconsideration, which it did not do, despite the explicit invitation.
They did ask for further briefing.
They requested a reply brief, which was denied by the board.
Yes.
And there is no rule or regulation requiring that a reply brief be accepted at that time.
So the board deliberately deprived them of due process.
No, Your Honor. The board denied a request for a specific brief at that time, which was not required by any rule or regulation. At all times, Lyon had an opportunity to file a motion for reconsideration. The member Kaplan, in his dissent from this case, explicitly invited them to do so, and they chose not to.
Where's your law that says they've got to do that to preserve the issue for appeal?
Well, Your Honor, I'm raising this point with regard to Lyon's due process claim, that they had no opportunity to be heard. They did have an opportunity to be heard by filing a motion for reconsideration, and they did not take that opportunity.
But that's not a waiver. That's what our D.R. Horton decision said.
Okay, so with regard to the scope of the mandate, let's say that this court...
We've done enough about the mandate. Let me ask you about, if you don't mind, if my colleagues don't mind, on the merits. I don't understand the ALJ's, if we were to get there, interpretation of the last chance agreement. Mm-hmm. So would you explain why when he filed 3 or 4 grievances within the last several months before that last chance agreement, not one of them had any merit, why they couldn't get upset about that? Because every time the union steward files a grievance, someone has to come in and investigate. That itself may upset the ordinary work processes, both by taking time out of the workday, by a diversion of resources of the human resources, and also by the people who he talks to, who are the union members, who say, no, I didn't say that. So why aren't those bona fide bases for last chance?
Two responses to that, Your Honor. First, factually, Mr. Colon did file a number of grievances during that time period that were either meritorious or were not problematic in Lyon's eyes. And so, for that reason, were not listed in the last chance agreement. So it's not the case that he had an unbroken string of grievances that Lyon found to be problematic because they purportedly contained misstatements. Secondly...
Well, there were at least 4.
Yes, there were grievances that Lyon listed in its last chance agreement. The standard when it comes to grievance filing is whether the conduct is indefensible. That's because this grievance filing is at the core of protecting...
Well, when you say that someone said that the that the union members were out to sabotage the company, and it turns out when you run that to ground out of 3 or 4 sources, that's just flat not true. I mean, that's a pretty explosive comment.
I would disagree with Your Honor's characterization of the investigation that Lyon performed. In that instance and in others, what Lyon did was they interviewed the management official who had been accused of wrongdoing, here been accused of making a comment about sabotage, recorded their denial. In that exact instance, the human resources representative admitted that it was a one man's story against another's, one man's word against another. And they concluded, because Mr. Cologne and the management official did not agree that the management official had said that explosive comment, they concluded that Mr. Cologne had made a misrepresentation. And not only misrepresentation, but an intentional fabrication of fact. The board found, and I think reasonably so, that that's not a fabrication. That's looking at what two people have said and concluding that one is a liar. I could go through, example by example, but in each instance, that's essentially what happened here. So the last chance agreement was premised on Mr. Cologne's core Section 7 activity. The board found that he did not lose the protection of the act in filing those grievances and found that the discharge was unlawful. I will note for your honors that the discharge did not turn on an Atlantic Steel analysis. Atlantic Steel was not invoked in that analysis. And so insofar as the court is concerned with the board's change of that standard, it does not pertain to the discharge of Mr. Cologne, only to the discipline of Mr. Cologne that preceded the discharge by about a year.
Well, let me ask another question. Suppose we were to disagree about the last chance agreement, and we were to agree about the two previous disciplines, that substantial evidence supported the idea that those were unfair labor practices. What, if any, remedy would there be since he's no longer on the payroll?
Well, he's no longer on the payroll because he's been discharged unlawfully, and so.
Well, I know that, but suppose we were to find that to be vacated.
If you found that to vacate the discharge.
Right.
I understand that. Well, in that instance, the court could either remand if it disagreed with the analysis, or simply,
But why
deny
doesn't-
enforcement. If enforcement was denied as to the discharge, the rest of the case would still stand. The discipline and the unlawful threat that the board found would still stand.
And what would that mean? That would just mean they post notices all over the
Yes, the board ordered a cease and desist from unfair labor practices, including a notice posting, and also that the unlawful discipline be removed from Mr. Cologne's.
And one other question about the remedy. I know I saw a reference and didn't run this down sufficiently. Did the order reversing the discharge assert that Mr. Cologne was entitled to anything besides back pay under the Thrive case?
I do not want to misrepresent the record, Your Honor. I believe that it did include a Thrive remedy for make whole.
Is that the Thrive case that this court heard a couple of months ago? Or is that another Thrive case?
Yes, I believe that's the same case, Your Honor. I would, to be certain, I would like to check the board's remedy to ensure that the Thrive
You can
remedy
do
is-
that.
Okay, I will, Your Honor.
All right, thank you.
Thank you, Your Honors. The board
All right.
requests full enforcement.
Mr. Kilbert.
May it please the court, Nathan Kilbert for the Intervenor Union. I'd like to draw the court's attention to Mr. Cologne, who is in the chambers, or in the courtroom today. He is the person most directly affected by the board's decision and your all's decision in this matter.
Well, he didn't have to refuse to sign the last chance agreement.
That's true, Your Honor. Had he signed the last chance agreement, he would have been subject to future discharge without the possibility of filing a grievance. He would have been in various ways.
Well, let me ask you, was there no one else at the plant who could take over the filing of grievances?
There are other union officials at the plant. What I said, or what I was intending to say, Your Honor, was that he could be, under that last chance agreement, terminated for any infraction of the rules, and no one in the union could file a grievance on his behalf. That's what the last chance agreement was intended to restrict. And that last chance agreement was unlawful.
That's under the contract. There's nothing to say that's contrary to the contract, though, right? Between the union and the company. It's only unlawful, according to the board, because it was an unfair labor practice in this instance.
I think that you're correct, that it's unlawful because it was unlawfully motivated.
That's what you say, yes.
Yeah, indeed. And I would like to focus and pick up on the issue that you all were just discussing with General Counsel's counsel, and that is the termination. We have this situation where, to take the example of the sabotage accusation, we have what the company HR representative admits was a one person's word against another situation, which they concluded meant that because their person denied it, Mr. Cologne must have intentionally fabricated it. It's worth noting that the administrative law judge who heard testimony from both men credited Mr. Cologne. It's hard to sustain the conclusion that he was intentionally fabricating any facts.
Well, sabotage is pretty clear. People may differ on insurrection, but sabotage is pretty understandable in layman's terms.
I think the issue is not whether what happened qualified as sabotage, but whether someone said over the radio that that employees had.
Well, maybe well, there were 3 or 4 instances.
That's true.
Though, and at least 2 of them were contradicted by fellow union members, right?
Your Honor, there is a tendency among individuals who are interviewed by various people in the course of an investigation. Sometimes they might tell one person investigating a situation that they remembered it one way and another. That's hardly evidence of intentional falsification.
Then how are we ever going to have that evidence?
Well,
It's kind of a nice circle, isn't it? That there can't be any intentional misrepresentation because, well, this person might have told somebody 2 different things.
With respect, Your Honor, the union employee who gave the diverging accounts was not called by the company as a witness. And so had that individual testified, I never told Mr. Cologne the statements he attributes to me, that would be pretty good proof of that.
There's no finding that those people were not telling the truth, though. I mean, you're now twisting what the ALJ found, because the ALJ found that the facts did not align with the grievance.
The ALJ.
So therefore, those employees the ALJ is not discrediting what the company interpreted. It is putting a different spin on it to say it wasn't, quote, intentional.
Mr. Cologne testified that he based his grievance statements on his conversations with affected employees and with other employees in the areas. That testimony was credited.
Well, let me just ask, when a grievance is a series of grievances, because this was a series, and maybe these grievances were provoked because suddenly he was screwing off his duties and closing his area to shut down for 2 days and ruining 500,000 gallons of some precursor component. Maybe he was worried about his own job, and he thought, well, I'm a union, which is exactly what Mr. Griggs said. He's a union guy. You can't fire him. You know, I mean, the ALJ didn't find that, but he files this series of grievances, a bunch of which have turned out to have no merit whatsoever. Don't you acknowledge that it's disruptive to the employment environment when the laborers are being asked all the time, did you say this, did you say that? I mean, it creates an atmosphere of suspicion and mutual distrust, doesn't it?
Your Honor, a grievance filing is a core activity protected by the Act that is a core function of collective bargaining relationship.
Well, it's like any of us filing a lawsuit. We may be aggrieved by somebody, but we don't file a lawsuit unless we think we have something. And you just don't try to, it's not the purpose of the union to continually disrupt the environment, right?
Your Honor, the analogy to a lawsuit is an instructive one here. I believe that Mr. Cologne's conduct, acting as a union representative not too differently from an attorney, his conduct here falls far short of something that would be sanctionable under Rule 11. I think that's fundamental to the analysis of the termination issue. I see my time has expired.
No, I have one other question. Did the board order other remedies according to Thrive?
Your Honor, I believe that no specific other remedies were ordered by the board pursuant to Thrive. I believe the amended order here refers to Thrive to the extent that there are other pecuniary losses that might be compensable under Thrive. I believe that would be, those losses would be identified in the compliance proceeding.
Okay. All
Thank you, Your
right.
Honor.
So it did order that possibility.
I believe that's correct.
Okay. Thank you. Okay, Mr. Cupp.
Yes, Your Honor. Just a few points. Regarding Thrive, in footnote 2 of line Elastomers 2, the second opinion, the board did address the Thrive issue, and so that's in footnote 2 of that opinion. One thing I want to emphasize here is that the last chance agreement that was issued to Mr. Cologne came well after multiple instances of Mr. Cologne submitting false information. In fact, one issue is he submitted a grievance on behalf of two gentlemen by the last name of Zamora and Fobbs. He submitted a grievance on their behalf. They were interviewed. They said that they did not want a grievance to be issued on their behalf. The company wasn't making them work in contradiction to the collective bargaining agreement. And after the company conducted extensive investigation, and as you mentioned, spent a considerable amount of time running these issues down, Mr. Cologne says, oh, never mind, I was misinformed. I'm going to withdraw the grievance. There were several instances of that. The last chance agreement recounts those instances. There were 4 instances or so that are set forth in the last chance agreement. That's a part of the record. And it was simply to say, Mr. Cologne, you cannot submit false information through the grievance process. That is not proper. Keep in mind that he also was disciplined twice, formally disciplined, for work performance issues. He filed grievances on those issues, and the region specifically found that those weren't unfair labor practice.
Now you mean, when you say the region, you mean the general counsel, right? Or
Well,
the
the NLRB. Well, it was Region 16.
Yeah,
who was,
so how come those were not specifically referenced in the LCA?
Well, they were part of the progressive discipline. Keep in mind, there's plant rules here that the company had. General counsel not once argued that the application or the issuance of the plant rules, which governs the conduct by employees, were ever at issue in this case. What was the focus of the last chance agreement was the continued submission of falsified information through the grievance process that caused the company to run through numerous traps, interview all types of folks, and it was like, Mr. Cologne, you can't do that. There were plenty of grievances that he filed that went through the process that were upheld. The company did not take action because of that. The company had a long history of working with Mr. Cologne on those grievances. But the last chance agreement was their way of saying, look, you cannot do this any further. He didn't even read it. You can't issue this to me. I'm a union supporter. And if you do issue it to me, it's an unfair labor practice charge. General counsel bought into that argument. And what we're saying is that a company can't be hamstrung like that with employees who engage in that sort of conduct. The last point I want to make is that before the Supreme Court right now are 2 cases dealing with Chevron deference. That's the Lopez Bright Industries and Relentless cases dealing with whether the longstanding Chevron deference doctrine is going to be upheld or jettisoned. And by all accounts, at least by my reading, it looks like the majority of the Supreme Court is ready to jettison the Chevron deference. And I would respectfully submit that before any decision is made in this case, that we wait to see what the Supreme Court rules on Chevron deference, because what is throughout the argument, at least in the briefs, is that this court needs to give the deference that the board has always had, and that they shouldn't question their policy-making or decision-making. So we have that decision coming down. It should be come down by the end of June, I guess, by the end of the term.
Well, let me, just pursue that hypothetically. So your argument would be if they overrule Chevron, that arguably Atlantic Steel is inconsistent with 10C of the Act?
Could be, and while I would...
And, well, wait a minute.
I'm sorry.
But right line is okay?
Well, yes. Well, right line. Yes, I do believe right line to be okay. Then that would be
Okay.
there. But I would submit, Judge, that you have us back. If after the Supreme Court, if they do jettison the Chevron deference and it does impact the case, of course the court can look at that and make the decision whether it has any impact on this case. But I don't know how the court's going to rule. I'm reading the tea leaves like everybody else.
Well, I personally never make predictions.
Yes.
But aside from that, when you say that, would this be a novel holding that the union can file repeated grievances that get dismissed or withdrawn, and yet the union cannot be sanctioned in any way for doing that?
No, it wouldn't be a novel holding, I don't believe. All the company was asking Mr. Cologne to do was do his duties as a union steward, and as part just submit grievances that didn't contain false information.
Well, but in saying, is it correct that they ruled on the right line test in this part of it as regarded?
I do not believe so, Judge. I think the administrative law judge and the board completely disregarded right line.
But they say alternatively that this would not survive right line. But I guess we don't know the answer since they never applied it.
Well, they never applied it, and going back to the due process argument, they never gave line Elastomers
Right.
a chance to argue it.
Okay.
Okay, you're done. Thank you.
All right. Thank you. Now I'm losing my voice.